Before this courtroom session even begins, you can already feel the tension building. 2 defendants. 2 separate cases. But one judge who isn't playing games today. What starts as routine requests for adjournments quickly spirals into something much more serious. Questions about honesty, accountability, and whether these defendants are truly ready to change. One is battling substance abuse while promising treatment. The other claims progress but admits to slipping under pressure. But here's the real question. Will the court believe their words, or will their actions speak louder? Stay with us, because what happens next takes a sharp turn that neither defendant saw coming.
It looks like it's their model is a 12-step type approach. It is inpatient.
On an amphetamine of some type.
Excuse me, Judge?
On an amphetamine of some type.
You mean prescribed? Yeah, I don't believe so, Judge.
This should be clarified. So why is she testing positive for amphetamines?
Your Honor, I believe this was the initial test after arraignment. We are asking for an adjournment.
Will she test clean today?
I'm sorry?
Will she test clean today?
I'm not sure, to be honest.
You're not sure?
I haven't used, I know that, but I don't know.
I think she's, it's my understanding she doesn't know the half-life of it, Your Honor. I believe her initial test was
That was she saying?
Or the 5th.
When's the last time did you use?
It was a couple days ago. That's why I'm seeking in-house treatment. Your Honor.
Your Honor, I do have, documentation here that she is seeking to address the root cause of any of this behavior. Like I said, she has an intake tomorrow. I can, it's at 1 p.m. That's in Richmond. She is here this issue today. I offer it to the.
She tests.
Right here, the defense is making a classic move, requesting an adjournment based on upcoming treatment. In many courts, judges are willing to give defendants a chance if they're actively seeking help, especially in substance-related cases. But here's the catch. Timing and credibility are everything. If the court believes this is a genuine step toward rehabilitation, it can work in her favor. But if it feels like a delay tactic, or worse, inconsistent with recent behavior, it can backfire instantly. So ask yourself, is this a real attempt at change, or just a last-minute effort to avoid consequences?
She tests on the 6th. She's positive on the 6th. I'm now here on the 12th, and she's using by the 10th. I have no guarantee that she's going to make it even to treatment.
Yeah, I promise you I will have my 4 kids with me, sir. Your Honor.
You know, she has a lot at stake.
I understand that, including her life. I'll adjourn the probable cause conference March 19, 2026, 9 a.m. This time the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Laquita Thompson.
And Assistant Public Defender Nick Vukovich on behalf of Ms. Thompson, who's now approaching. Can you please state your name for the record?
Laquita Thompson.
What do we do? You're seeking an adjournment?
Yes, I am seeking an adjournment, Your Honor. And I'm prepared to address the corrections report.
Pardon?
I said there was a note for community corrections reports. I'm prepared to address that.
And
this is where things start to unravel. The judge zeroes in on a critical issue, drug use. Not just any use, but unprescribed amphetamines. That's a major red flag, especially when you're standing in court asking for leniency. Judges rely heavily on consistency. If you're claiming you want treatment but still testing positive, or can't clearly explain why, it raises serious doubts. And here's the legal reality. Bond conditions often require strict compliance, especially sobriety. Violating that? It puts everything at risk. So now the focus shifts. This isn't just about treatment anymore, it's about trust.
February 22nd, she blew numbers. We're at her 3 blows, then she took an EEG the next day. It came back.
Yes, Your Honor. In addressing the alleged violation, my client does admit to drinking on that 22nd date. It was unfortunately she did lose a friend of 24 years, someone she worked for and has known for a very long time. And unfortunately, as part of the grieving process, she does admit she did have a moment of weakness and there was a mistake and she did drink.
That answer right there, "I'm not sure," is one of the worst things a defendant can say in this situation. Courts expect accountability and clarity. Uncertainty suggests ongoing use or lack of control, both of which weaken any argument for release. And notice how the judge presses forward, because at this point, it's not about promises, it's about evidence. Let me ask you, if you were the judge, would you take that risk? Would you allow someone back out knowing they might not even pass a drug test today?
She did drink. She is working very hard on maintaining the good strides she has made in her life. She currently works 2 jobs, one where she works approximately 12-hour shifts on her feet at a manufacturing factory. She has done community service. She attends AA meetings. I actually do have AA sign-in sheets I can provide to the court and the prosecution. She attends them both in person when she's able to and on Zoom when her work schedule does not allow her to make in-person dates. I do want to note, prior to being placed on the sober link, she did have no violations on the Scram tether. She had to be placed on the sober link due to issues with her ankle, and that was why at the previous PCC date you allowed her to switch over to the sober link. I do note I do understand there are several late tests. However, I do want to note several of those tests she did test within 10 minutes after the time frame occurred. I think 7 of those total. And for all of those late tests, she was negative. She does, as I indicated, work on a manufacturing line, so sometimes there are moments where she cannot physically step away from that line due to the ongoing working process, as it would be obviously a process issue for the process of work, but also for safety down the line. She has indicated that she has reached out to her supervising agent to discuss these matters when she does.
This is the turning point. The judge lays out the timeline, and it doesn't add up. Positive test on the 6th, still questionable by the 12th, and a promise that hasn't been fulfilled. In the legal world, this pattern signals noncompliance. And when a judge says, "I have no guarantee," that's essentially the moment the decision is made. Because the court's priority isn't just giving chances, it's protecting the integrity of the process. And right now, that integrity is being tested.
When she does have a late test, she is actually working on obtaining a house and was actually supposed to assign on that house today. She is doing a lot of work to improve her life, continue doing what she must, and I think it is clear that she is attempting to do with everything within her power to comply with the bond conditions. So at this time, Your Honor, I would be requesting that she have a second chance and that her PR bond be maintained.
Any response to the people?
My concern, Your Honor, is that we was on a tether and we agreed to change her to a sober link. Now she has these issues.
Yep.
And it was right about the graciousness of the court to modify those conditions. So, near as I can see, there's an option.
What's that option? Lock me up.
I will adjourn the probable cause conference to March 19, 2026, 9 a.m. Defendants bond this time having it
Oh my God.
both defendants remanded.
I have 2 jobs.
2 defendants. 2 different stories. But the same outcome, remand into custody. In the first case, the court saw inconsistency, uncertainty, and ongoing substance concerns that made release too risky. In the second, even though there was progress, jobs, meetings, effort, a single violation tied to alcohol was enough to tip the scale. And that's the harsh reality of the legal system. progress matters, but compliance is everything. Judges are balancing second chances with public responsibility, and sometimes, even one mistake can outweigh months of effort.